Hello, 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 everyone. Hello, hello, hello. Happy Tuesday, everyone. They're better than Tuesdays. And then put in the chat where you're from and or hold up any pups or kittens or pigs or pets or anything that you may have. All right, we have Houston, Wisconsin, DC, Florida, Oregon, Texas, Seattle, Philly, Virginia, LA. Going way too fast. All the things. Phoenix, Idaho. I'm trying. New York, Indianapolis State College, San Diego. Awesome. All right. I'm going to share my screen. Let's see. Look at that. We have Tom. All right. So welcome everybody. You are at the LGBTQ Pride Planning webinar on LGBTQ estate planning and all the things. We're going to have a Q&A at the end, and we'll talk about and answer any and all of your questions. There's a lot going on, and it's one of the impenetrable, inseverable line of defenses that we've been using to protect ourselves in all sorts of calamities over decades is estate planning. And so everything that's going on is tangentially related, in my opinion. So we'll take questions at the end. Housekeeping. So yes, as Nancy said, please mute your mic. Don't have to say this to an LGBTQ group, but I like to anyways be respectful and kind. I feel like we were just born that way, but when you do ask questions, when we get there, keep questions brief. There will probably be a lot. I want to stay as long as you want to stay. And so, but in order to answer as many questions, just keep them brief so that we can get as many people through as possible. As far as an agenda, a lot of you, we came up with an FAQ of questions that folks most commonly have about LGBTQ Pride planning, about the platform itself, about how it works. So I will go over that with Tom, and then we will go through the 9 documents and describe them and go over them and how they work and what they do and why you need them and all the things. And then we'll do a hot seat. So we are going to give away 2 Pride plans. One will do and actually do a design meeting as if you were meeting with me one-on-one, and I'll walk someone through design meeting and ask them all of the questions as if we were designing their LGBTQ estate plan. And so then you follow along and take notes as if I were working with you directly. And again, during the Q&A, if you have any questions about you specifically, I'll take them. But the goal is that by the end of this meeting, with discussing the documents and with the design meeting that you'll be able to watch a couple go through, that you will be able to design your estate plan at home and then just go over to Pride Plans and type it all in, and poof, you are good to go and on your way. Just like that, poof. That's a legal verb. And then we will do Q&A and answer all of your questions. And then we'll talk about other ways in which we can stay in touch off of social. So who am I? So I am Angela Giampolo, and I founded Giampolo Law Group, my law firm, 17 years ago. And the realities are, if you would have told me 17 years ago that we'd be where we are right now, I wouldn't believe you. And so, it's very disheartening to see the ebbs and flows and sort of where we're at. But like I said, LGBTQ estate planning has been the most impactful and impenetrable line of defense that we've been using for decades. And then post-election with Tom Yeagers, my co-founder, we founded LGBTQ Pride Planning in order to bring these documents to folks nationwide in a financially affordable and digital, completely online way, and just make them accessible to as many people all over the country. So that's LGBTQ Pride Planning. And then I founded the Caravan of Hope, which will actually be launching in March 1st, the whole month of March. I'll be traveling 5,000 miles and stopping in 16 cities, providing pro bono legal services to LGBTQ folks Added 2 cities from the last time I did this, Iowa City and a small town between Pittsburgh and Philly. So 16 cities, 5,000 miles, 30 days. I'll announce the itinerary. I'll do more around that in one of my legal Q&As so that if you're in one of those cities or you know folks in those cities, spread the word, come say hi. And yeah. All right, Tom, introduce yourself.
Hi, everybody. My name's Tom Yeagers. I am one of the co-founders of LGBTQ Pride Planning, as Angela mentioned. I began my career in law almost 20 years ago. A large part of that career was doing complex commercial business litigation for a large law firm, and then I was in-house with Marriott. But after 2024, Angela reached out, and I decided to pursue my passion, and that is to help and work with the LGBTQ plus community, which led me to work with Angela and then to co-found LGBTQ plus Pride Planning with her. So very excited and happy to be here.
Um, all right, and then so let's go through the FAQs. Tom, I'll stop sharing for a little bit.
Perfect.
All right, so one of the most frequently asked questions that we get is, after I go through the pride planning process, do I have to get a lawyer to review them before signing them?
Yes, the answer to that is no, you do not. So, for your estate planning documents to be effective, all you have to do is get them signed, witnessed, and notarized. And we provide you detailed signing instructions to make sure you get them done, executed properly and notarized properly. But there is no need to file the documents anywhere or to get an attorney to review them. Some counties and jurisdictions do permit you to file your will with the probate court, but it is not a requirement. You do not have to do so. So once everything is signed, witnessed, and notarized, you are good to go. And we also even provide you a care letter for how to take care of the documents and guidance on who to share the documents with as well.
And just a best practice tip there, even if you do live in a jurisdiction that allows you to file your wills or powers of attorney, I do not recommend that you do so, because if you want to update it, you have to unfile that one. You basically have to revoke the one that you filed. It's a court proceeding, filing fees, all the things, and then file the new one. So it's not just as easy as updating. The reason why some people do is if you have a hostile family member or members or any hostility, when you file your will, you have 30 days to let everyone on notice who could potentially take from you. And then you get to argue while you're alive. So instead of worrying about a will contest when you're deceased, you could do so while you're alive and have a court hearing. So that's why people file. There is a real reason why people do it. But if you don't have to, it's not recommended because it's very difficult to update. I see that between the two of us, I see that you're only licensed in 4 states. Can you serve other states?
Absolutely. So we design pride plans to produce state-specific estate planning documents. So the 9 essential documents that Angela will go over shortly. We design pride plans to produce state-specific documents in every single state, all 50 states. And how we do that, although we, between Angela and myself, are only licensed in 4 states, we collaborate with attorneys in other jurisdictions, have them review the plans, make sure everything is up to par in the forms that we're using, so we can provide those state-specific documents. Specifically, most of the state-specific documents lie within the powers of attorney that are used, but we make sure that those are what your state expects, so we can produce documents in all 50 states.
And also, LGBTQ Pride Planning is a separate entity from Giampolo Law Group, which is a law firm. So think of it as a queer competent LegalZoom, right? So LegalZoom can provide documents in all 50 states. So can LGBTQ Pride Planning. But I told myself if I ever got into the legal document automation space, that there would always be a set of eyes, a human set of eyes going over the documents, as opposed to you just fill out the form and you get what you get. So again, you think LGBTQ Pride Planning, that is a separate entity. And then there's Giampolo Law Group, my firm working with me directly. We can, through me, we can work with folks in upwards of 30 states now through, like what Tom said, co-counsel relationships in those states. So I am not licensed in those states, but Crystal Richardson is my co-counsel in North Carolina. And so I can work with folks in North Carolina with my collaboration with Crystal and 30 some odd other states. Um, so that's how that works as far as our licenses versus pride planning in the law firm. If I move to another state, do I need to update these documents?
The shorter answer is yes, you should. Many of the powers of attorney and the documents that you receive can be used across state lines, but we always advise updating specifically the powers of attorney in your documents generally to the state in which you are going to permanently reside, because most of the professionals, healthcare, banking, financial, are used to seeing powers of attorney that are in the form that their state expects them to be in. So while legally speaking, they should honor your power of attorney from another state, they're often reticent to do so, or it can be difficult to get them to do so in certain situations. So we always recommend updating your documents should you move to another state. Plus, your will should always be domiciled in the state of your residence. So you should always update your will when you move anyway, for that reason, because you want it domiciled in the state where you reside. So we do always recommend that you update your documents when you move to a new state.
And I always tell people it's called estate planning, ing, because plans are meant to change. It's a verb, it's a gerund. So this will be the first time putting it together, and then tweaks are super simple. And that is a segue to the next question. If I do need to make said changes or updates in the future, how does that occur?
So eventually, we do plan on offering a subscription that will allow for unlimited updates on an ongoing basis. But until that launches, you can absolutely make updates to your plan at any time by reaching out to us at info@prideplans.com or tom@prideplans.com to get those updates made. For your first 3 months after we send you your documents, any updates that you may need are included. But after that point in time, we'll charge you based on the nature of the update that you request. But it will only ever be a fraction of what the original cost of the plan was. So, for instance, if you got married and wanted to update from domestic partnership to spouse and include the defensive definition of spouse that we include in all of our documents, you can do so by just reaching out to us. And the cost to do an update like that would be, say, for a couple of $150 to include that throughout all of your documents. So it's a fraction of what you originally pay to make substantive updates after 3 months, but you can always make updates, and we are always here for you should you need to make any updates.
That defensive definition of spouse that Tom mentioned, it's a definition that I came up with after the election to solve for the concern that, well, if 3 years from now we are not considered spouses, then do I have to update my documents and remove spouse to put domestic partner, right? And so a lot of folks were saying to leave spouse out altogether, to leave wife out, husband, spouse, and just say, I, Angela, appoint Carla, and have that be that. But I was super passionate around not doing that because you are married, if you are married, right? And so that ultimately the definition speaks to the designator. So I do agree with not genderizing it and removing wife, husband, and using spouse as safest, but that the word spouse, what if I said the human Thomas, the a-hole Thomas, right? Like at the end of the day, it's a descriptor, lovingly, and does not have legal significance, and so it's just a definition that we put in all of your documents, except this one, which I'll go over later. This is the one document where I remove the mention of spouse or domestic partner purposefully as to not out you by virtue of this card, but otherwise it's in all of your documents, and that's the purpose of it. Do I need a trust? What's the difference between your will-based plan and the trust-based plan?
Great question. So the trust-based plan offers everything basically we have to offer. So all 9 essential documents, the most important of which is the trust. The trust-based package is for you if you first own or plan to own real property. Second, you want to make sure your loved ones can avoid probate so they can receive what you have left them faster and cheaper in death. Third, you want to make sure that you as a couple can co-own assets and maintain ownership in death regardless of marriage. And fourth, if confidentiality is important to you, so you don't want to own property directly in your name, you'd rather own it in the name of a trust. So if any of those really four reasons that I just mentioned apply to you or are of interest to you, then the trust-based package is really what you want to go with, and it offers the most comprehensive protection that we have.
Yep. And we'll talk more about this as I go through the documents, but the revocable trust is also your marriage recreation tool. It's what we've been using for decades to recreate a marriage. And post-election, whether folks are 24 renting a 300 square foot apartment or 65 and established and property and all of the things, everybody is getting a revocable trust for marriage recreation, marriage protection. If your marriage is like a castle, the revocable trust is a moat around that castle. Okay. And then I want to make sure, and this has to do with the questionnaire in particular, and a question that people have when they hit this particular question in the questionnaire. I want to make sure that I leave everything to one another first, but then who do I put as the primary and alternate beneficiaries on the
Yes.
form?
So when you reach that section of the questionnaire, which is basically where you leave your assets to your loved ones, there will be two sections. It'll be a specific bequest and residue beneficiaries. Most people use just the residue beneficiaries because a specific bequest is designed when you want to leave a specific asset or a set amount, like $5,000 to so and so basically off the top of your estate, you would do a specific bequest. But most people just want to leave their assets in percentages to their loved ones, however many that may be. So if you think of it as 100% of the pie, you divvy that up, depending how many beneficiaries you have by percentages, and you leave them each that percentage of the pie, right? So if you want to make sure that everything goes to one another first, if you share residue beneficiaries, so if you both are going to have the same set of residue beneficiaries, basically, automatically you will leave everything to one another first. So the questionnaire will default and the documents that come out will default to leaving everything to one another first. So if you do that and you share, your primary residue beneficiaries will be the first set of those that you want to leave your assets to. Then it will ask you about contingent beneficiaries, and those will be a new set of people that you have not previously mentioned that you want to receive in the event that all of your primary beneficiaries cannot receive. So that's how that would work if you share. If you do not share residue beneficiaries and you have different ones that you want to name, and if you want less than 100% to go to your partner or spouse, you should then list your partner or spouse as one of the primary beneficiaries along with any others and delineate the percentage that you want to leave to them. So that's how that section works within that questionnaire. And we do have a guide, just to mention this. When you go into the questionnaire, and I think we'll talk about how it works in next, but when you go into the questionnaire, there will be a reference guide that walks you through all this step by step that you can download and have by your side when you go through the questionnaire that walks you through all these things as well. So that is a great tool when you go into the questionnaire that you have access to that you can use.
All right. And then what about how it works? Do you want to talk about that before I dive in?
Absolutely. So, as Angela mentioned, there is Pride Planning, LGBTQ plus Pride Planning or Pride Plans, and Giampolo Law Group. The difference between the two, one is a law firm, one is a website designed to facilitate LGBTQ plus estate planning, designed by legal professionals, but it is technically not a law firm. So the reason we developed Pride Planning is to offer these same estate planning documents that you would get through working with Angela's firm, but you get them at a much lower price point because you're removing the one-on-one time with attorneys, a lot of the hand-holding or meetings that you would have as part of that process, which can often drive the price up or increase the price of estate planning. So we created Pride Planning, which is basically all done online. So you would go visit the website, pick the package that works best for you, make your payment, and then you basically launch into a questionnaire that you can save your progress along the way. You don't have to finish it all in one stop, but you go through a guided questionnaire that's designed to gather all the information we need to create your estate plan. Once you finish that questionnaire, we get notified. We then review everything, reach out with any clarifying questions that we may have. But then, as Angela mentioned, there are still human beings behind Pride plans that review the questionnaires, help draft your documents, make sure everything looks correct, and then sends everything to you for review, and then also works with you to make any edits or updates that you would like to see within the documents. And just to mention real quick, it's already been put in the chat, but I think we'll put it in again. For all of you that are attending this webinar, we are offering a webinar only discount. For those that have attended, it's a one-time discount that will be available through Friday of this week. There is a website where you can access it. And basically, we're taking $200 off the couple-based trust plan, 150 off the couple-based will plan, and then if you're a solo individual, we also take a corresponding discount off of those plans. And the link is just put in the chat. But for all of you attending, you do have access to that one-time discount that's available through Friday. Everything works the same way I just described if you choose to go through Pride plans. But you can access the discount only by accessing this special web page that's put in the chat. If you want to work with Angela, I'm going to pitch it to her to describe what that entails and what that involves with working directly with Angela through Giampolo Law Group with your estate planning.
Yeah, so Tom already alluded to it. I won't spend a ton of time on it, but basically the difference, and I saw Kathleen Donnelly ask, so what's the difference between working with Angela versus Pride Plans? I mean, you get to work with me. No, the one-on-one, the guidance, there's a quiz up top when you go to Pride Plans. You know, it's a self-directed online platform, and it's a one size fits all is not for everyone, basically, right? And so kids from a previous marriage or properties in multiple states or family hostility or polyamorous or there are a multitude of reasons why you may have a more complicated estate planning and may need to work with someone one-on-one. So and my typical fee is $42.50, and I'm discounting as well $500. So instead of $42.50, it's $37.50 all in. So there is a difference, but again, we meet. We basically, the process is we have the design meeting, we have a clarity call. This is basically the clarity call. I'm going to run it like a clarity call, so you get that. And then the design meeting, which you'll see, which I'll do with one of the winners. And then we have a draft meeting. And so then the following week, and we meet weekly, and we have the draft meeting. We go over your documents one by one. Then from there, we send you your documents for your line by line review. And then any meetings that you may have that come up from your review, we have as many meetings as you need. The record is 9 meetings and a therapy break. Same flat fee. I'm here for it. And it's whatever it takes. The goal of that 2-week review is for you to say, get it, got it, good. Let's sign. Okay. And if I'm working with folks out of state, as I mentioned, we're working with folks in approximately 30 some odd states. We have a company that we work with. They're like the Uber of notaries. And so we then schedule the notary, and poof, 2 witnesses appear at a date time that we've scheduled. Someone from our team will also appear via Zoom to make sure that the signing goes off without a hitch. Actually, and I want to take a moment to thank Jackie, who's in the comments and answering questions. She's one of my paralegals. And so thank you for answering all of their questions. But so that's and then we also walk you through, and we'll talk about the trust funding. We also walk you through the trust funding. That's not a part of Pride Plan. So and we'll talk about what trust funding means. But Zoom has made me very prop focused. This is your trust, and the water in it are your assets. And when you sign it, the water doesn't just appear. You actually have to put the water in there. So at signing, you just have an empty water glass, right? And then we start the process of putting your properties, your assets, your whatever into the trust. And so we walk you through that process as well. So perfect segue. I will eventually return back to the PowerPoint, but it basically says everything that I'm about to say. So when I'm on a clarity call, one of the first things that I like to educate folks on is the difference between estate planning and marriage. Okay, so estate planning, you think marriage, right? With marriage, a lot of folks don't realize that, but with marriage comes 1,138 state and federal privileges. It is nothing to sneeze at. It is what we fought for. They are financially significant, fiscally advantageous privileges. 1,138 of them. I say that being Canadian, where there are 4. I come from a long line of straight people that never got married because there's no point. It's truly a religious institution and nobody wants it. I never thought I'd agree with Rand Paul on anything, or he, me for that matter, but there we were on Newsmax making for horrible TV because we're in complete agreement. They were in our ear, like, why are you two fighting? And he blurted out, because I agree with her. If my people wanted marriage to remain a religious institution, we shouldn't have tied 1,138 state and federal rights. That's all her people want, right? So, and, you know, and they touch on everything from Social Security survivor benefits, Medicaid, immigration, taxes, you name it. But there is zero power inherent in marriage, unbeknownst to most folks. I got passionate around this topic 20 years ago with the Terry Schiavo case, if you remember that. Straight married cis couple. He was not her healthcare power of attorney. She did not have an advance directive for herself, and he was not her healthcare power of attorney. 2025 was actually 20 years since her passing, and Netflix made a documentary, so if you haven't seen it. But if a straight married cis couple couldn't effectuate the wishes that they had for one another, right? Because it wasn't in writing, what made us think that we had a leg to stand on? And so then I entered law school in 2004. Well, and then when that happened, she was 29, had a heart attack. If people don't know this story, I don't want to assume that you do. So Terry Schiavo was 29. They didn't have much, right? They didn't have a house. They didn't have kids, right? Who at 27 and 29 has their estate planning? She had a heart attack, ended up in a persistent vegetative state. And he testified that their pillow talk at night was that she said, I will haunt you until the day you die. And unfortunately, pillow talk is not binding. And they duked it out in litigation. He went bankrupt after 8 years. She languished on life support for 15 years, 1990 to 2005. And then I entered law school in 2004, had the big aha moment of, wow, these 1,138 state and federal privileges touch on every aspect. They are fiscally advantageous, financially significant privileges, and zero power. I feel like something happened, what made me very well positioned for this moment in time to be doing LGBTQ estate planning for folks is 10 years ago when we got marriage equality, I never stopped treating you as unmarried, right? Like ultimately, something happened 10 years ago where we got marriage equality and we breathed in legitimacy for the first time. We were seen in the eyes of the law and we breathed in legitimacy and we mistook that feeling for power. And it wasn't. And now that the legitimacy is being ripped away violently, we're left realizing, oh shit, we have no power. And there's a return to these documents when actually we never should have moved away from them. Right? Now, even if everything were puppies and babies and roses in this country, right? Everything, Hillary Clinton won in 2016, PS, if you didn't know. We live currently in an alternate universe, one that I choose to spend most of my days.
There you go. You're
and
welcome.
meditate in between meetings. Even if that were true, even if that was our reality, you are only considered married in 37 countries out of 195 that fly a flag. A fraction. So when I said that 10 years ago, when you got marriage equality, if any of you here have been married for 10 years, if we would have met then, I would have done what I call LGBTQ estate plan. I view everyone as inherently, predominantly, statistically, globally unmarried because you are. I need you to be safe no matter where you are. Right? And that's where this document comes up that I alluded to earlier, the hospital visitation authorization form. So again, I just always start out all of my calls. And I spoke to someone earlier and she was like, we've been meaning to do this forever and all of the things. Everybody in this country, Terry Schiavo as well, 29-year-old cis straight woman, everybody needs these documents. My straight couples get 5 and my LGBTQ couples get 9. And the additional documentation is, again, to plan for the fact that you're not considered married all over the world, that we have extra considerations, that we have additional things that we need to protect against. As I go through the 9 documents, I'll talk about what, from an estate planning perspective, why we do what we do. Because again, everybody in this country needs estate planning. And then there are additional documentations, ways in which we use the same documents straight people do, but we creatively use them in other ways to protect ourselves. Okay. But I always like to say that because, I'll get comments and trolls and whatnot. Everybody needs these documents. Yes, everybody does. And, that was proven by Terry Schiavo 20 years ago. Everybody needs estate planning, but LGBTQ specific estate planning is meant to make sure that we're protected everywhere and all the time. So, and yes, this, there will be a recording and that we'll send out. So again, when you think about marriage equality and you think about estate planning, with marriage comes privilege, 1,138 state and federal privileges. With estate planning comes power. We deserve them both. We deserve them both. But if I were told I was going to an island tonight and could only take one thing with me, privilege or power, I would choose power time and again. All right. Whatever happens to marriage equality, and join the legal Q&As that I have every other Tuesday, where we discuss cases. We discuss the Hecox case and the oral arguments that took place today and the impact that case about trans kids in sports will have on marriage equality. The massive impact that case will have in dismantling LGBTQ rights. And so definitely join us and we'll talk about those. But so when we talk about estate planning, again, the 9 documents, first and foremost, what I call the healthcare trifecta documents, the 3 healthcare trifecta documents. The number one, most commonly known by folks as the healthcare power of attorney. The healthcare power of attorney, how I do that one differently for us, for LGBTQ folks, one of our biggest challenges, one of our everyday obstacles at a hospital, something I get emails about at least monthly, is establishing our HIPAA status to one another. Who are you to the patient? So the majority of estate planning attorneys will make the HIPAA waiver yet a separate document from your healthcare power of attorney. I used to too, 17 years ago when I started out, until I really started my practice and working with LGBTQ folks. In my first 3 years, I had 7 couples, not leave the HIPAA waiver at home and have the healthcare power of attorney and nobody would talk to them. Man in a hospital bed, woman come running and crying, "Man, let me take you to your husband." No questions asked. Woman in a hospital bed, woman come running and crying, "Skirt." What's your relationship to the patient? Who are you to the patient? All of a sudden, HIPAA issues come up. Okay, so and then it wasn't that I didn't give my folks the HIPAA waiver. It's that Angela stresses power. Where's the power document? I'm going to grab the healthcare power of attorney, rush to the hospital, leave the one little page HIPAA waiver at home. Clearly, I'm a slow learner. It took me 3 years, 7 couples, but I got there. All I did was combine the 2. All right, healthcare power of attorney with HIPAA. Second document, and someone asked about this in the comments, is your advance directive or living will. All right, I prefer the word advance directive because I'm literal, and that's literally what you're doing, is in advance, when signing the document, in advance of being in said coma, you are directing your healthcare power of attorney about your end-of-life wishes. Nobody's name but yours appears on that document. They're your end-of-life wishes, allowing it to go from one another to your sister, to your best friend, to whomever, but you don't have to update that document unless your end-of-life wishes were to change. And then the third document, again, I've mentioned it a couple times, is the hospital visitation authorization, HVA, hospital visitation authorization form. I do 2 of these, 1 and 2. So HVA 1 is for one another. This one, the only one that we shrink down, laminate, and you hold on to one another's. Again, one of the 1,138 state and federal privileges tied to the institution of marriage is automatic visitation rights to your spouse. If you are somewhere where that is not recognized or it is challenged, then you don't automatically have that. Okay, so if you're on the Great Wall of China, you're just two people. Get nipped by a lion in safari in Tanzania, I don't want you yelling, it's illegal to be LGBTQ+, I don't want you yelling, that's my husband. Okay, so to my point earlier, that's why we remove the mention of spouse. This is merely a contract. I, Angela, appoint Tom. Okay, and really it doesn't say appoint. There is no appointment with this document. This just lets him in the room. Okay, so I, Angela, want Tom to be given first preference to be able to visit me in any medical or treatment facility, and that he be given final determination as to all others who wish to visit me, whether or not those people are related to me by blood or by law. Appointing him the CEO of my hospital room. And HIPAA, we love her, we put her everywhere. Okay, so you're in the room, they have to talk to you, but you have no power. It's great to get this done, right? Hashtag adulting, good merit badge, all the things. It's great to get this done, but actually having access to them if and when you need them is key. So whether if you go through Pride plans, I recommend that you take your big bundle of signed documents afterwards to Staples, a UPS store, whatever, and get them individually scanned in. For my clients, we individually scan in each of the documents after the signing, and then we email them to you for you to upload to the cloud. It's great to get this done, but actually, you're not going to have the packet of originals in the car accident. You need to have access to them if and when you need them. Okay? So again, this gets you in the room. In 17 years, this has gotten two couples their final 5 minutes with one another and countless injuries. Super, super important. Why I love contracts. Documents generally, you don't have to convince anyone. You don't have to reason with anyone. You don't have to explain yourself. You just get to do the thing. Okay? Then the HVA2, the Hospital Visitation Authorization Form 2, is a global visitation form. Three groups of people go on the HVA2. First and foremost, your chosen family. Friends that are close like family. All right, 4 people walked me down the aisle. Only one was related to me, and I kind of like the other 3 better. But they'd be stuck in the lobby, right? So who is your chosen family, your Golden Girls crew? And then the second group is, I've only been doing this since the election. It's in an abundance of caution, and that is one another's families. Now, if you're not legally married, if you have a domestic partner, then their family are not your in-laws, right? So your domestic partner's mother's not your mother-in-law. She's just a human in the world. But if you're legally married, we're related to people by 2 ways in this country, by blood and by law. And your legal relationship makes it so that your mother-in-law is as much your mom. Your brother-in-law is as much your brother. So to the extent that we like them, if we don't like them, that's fine. You don't have to put your in-laws on your visitation list. But to the extent that you like them, I want one another's families on the other, because if you're somewhere where your marriage is not recognized, or you're in a state where it's not going to be recognized, then your in-laws are not your in-laws. All right, they're just chosen family. So I want to get ahead of it and put them on there. And then the third group may not apply to you, but if it does, it is super powerful. All right, and that is your, what I call a do not fly list. Are there people that are related to you that you would not want to be able to visit you? Okay, super, super helpful. Another set of eyes on those people. Yes, your power of attorney can make sure that they're not allowed in, but what if they go home after 36 hours to eat, sleep, shower, all the things? And then dad coming in and you don't want that person there, right? So how the healthcare power of attorney uses that form is they will hand the HVA2 to the charge nurse. They will type in all these names. The hospital will not have an altercation with your do not fly list, but they will call the healthcare power of attorney and make sure that they get back ASAP. Okay, super, super helpful. So that is the healthcare trifecta. Your healthcare power of attorney with HIPAA, your advance directive, end of life, DNR doc, And then the third is the HVA 1 and 2. All right. Then the 3 legal financial documents. So the most powerful, in my opinion, the most powerful document out of all of these while you are alive is the durable power of attorney. The most significant, powerful document. Post-election ICE workshops that I would do for restaurant owners that wanted to protect their undocumented workers. One document that I would give them out of all of these, 5 copies of, the durable power of attorney. Someone's detained. We don't hear from them for 9 months. We can't talk to them. Who's paying their mortgage? Right? They come out 9 months later, their lease is terminated, their stuff's thrown away. Who can live for you as you if you are unable? And the reason, and again, most estate planning attorneys only care about and plan for death and disability. Shocker, everyone. Shocker. Spoiler alert, you're gonna die. It's gonna happen once, and hopefully your big long life, and we will plan for it outside of probate. You've heard that. I'll explain what it is. We will plan that around that and all the things, but we may never become incapacitated. My goal, live life, Thelma and Louise it off the cliff, and then die. Right? No incapacity. So most estate planning attorneys only give you 1 durable power of attorney for potential incapacity. I give us 3. I want you to have, again, the documents, right? Being able to do the thing. And the durable power of attorney is the doer of all things. There is nothing you can't do for and on behalf of one another with the durable power of attorney. The reason we do 3 originals is someone may need an original. Title companies like an original, right? I had a couple, Paul and Scott. Paul was stuck in Chicago, O'Hare, worst airport known to man, and they were closing on a house Friday at 2:30, and he wasn't getting back in time. And Paul called me at 6 a.m. I typically don't pick up phone calls from clients at 6 a.m., but they typically don't call. So I had a feeling something was wrong. I picked up, and he was like, there's no way what's that document where Scott can like be me or something, my mini me that you said? And I said, the durable power of attorney. Yeah, I won't get back for closing. Can he go as me? Yes. But someone bought a home in someone else's name who wasn't present. Kind of a big deal. Also a crime for all of you people that are like, whoa, how's going to, so there are statutes, there are protections at the end of the day. And it is purposefully a powerful document. But you can care for it in ways that protect it so that it only gets into people's hands when you need it. Those 2, for instance, had me hold on to all 3 for each of them. And then Scott came to the office and picked up a power of attorney for Paul and then went to closing. Okay, so there are ways in which you can care for those documents to make sure they don't get misused. But the idea being is you're choosing someone you trust implicitly. So and then so that durable power of attorney, you get 3 each, never expires. Never expires. It expires at death. And then the will and the trust kick in. All right, we got there. We got to the trust. We're going to explain the trust. So Zoom has made me very prop focused. This is your last will and testament. This is the revocable living trust. Your last will and testament is like the Titanic. This is your speedboat. Okay, so counterintuitively, you want nothing to flow through your will. Anything that flows through your will goes through the probate process. No choice. All right, there are 3 statuses upon which you can pass away. 1, someone who has no documents whatsoever. All right, they have no documents whatsoever. It goes through probate, and you don't have a say about who it goes to. Okay, so if you're unmarried, if you're married, you would a little bit, but not the contingent. Second is you die with a will, still probate, but you get to decide where it goes. Third is you die with a will and a trust, and everything flows through the revocable trust, which is your probate avoidance tool. And you dictate where it goes, and it's confidential. Okay, now probate. I'm going to assume one of the 280 folks here don't know what probate is, so I will explain it. So imagine that life is like being in the grocery store. You're in the grocery store. This is your grocery cart of life. You get to put whatever you want in your grocery cart. Lucky Charms, my favorite. House, 401k, all the things. Okay? The only way you get from the grocery store to your car is through the checkout line. You get in the checkout line and you're fourth in line. You're like, okay, fine, it will deal. And then you realize there's a 91-year-old woman ahead of you, and she hasn't even started cutting her coupons. You're like, oh my God, I'm gonna kill her. And there's only one lane in this grocery store, so you don't get to skip lanes. Hey, babe, you get in lane 3 and we'll see who gets there faster. Nope. One lane grocery store, and you got to stay behind this old lady. Then she gets to the front and she hands her first of 19 coupons that she cut. And it's expired. And she's not having it. Oh, you're going to take this coupon. It was in last Sunday's paper and it's good. I want a manager. We need an override on aisle 5. All right. Probate. When you check out, when you die, when you check out of life, the only way your assets get to your intended beneficiaries is through the probate process. It is long, it is glacial, expensive, government oversight, the manager with the override on aisle 5. To the extent that we can avoid a lengthy, costly court proceeding, we want to. So we created this hundreds of years ago in order to avoid the probate process. In this analogy, think of this as your Instacart. You get to put whatever you want in your grocery cart of life, skipping the checkout line, Instacarting everything directly to your intended beneficiaries. Okay, so your assets will get to your intended beneficiaries in one of two ways: through the checkout line of life or Instacart. You see no benefit to this, mind you. Well, LGBTQ folks do, because this is our marriage recreation tool. But from an estate planning perspective, you see no benefit to this type of trust. It's important to know this is a very basic trust. There are 88 types of trusts out there. The analogy I use there, or I liken them to cars, right? You wouldn't help your friend move in a smart car, and you wouldn't drive cross country in a Denali, or you shouldn't. Anyways, so when clients come to me, I put them in the right vehicle. This is a basic estate planning vehicle for everyone. Everyone should want and strive to avoid the probate process. It has zero creditor protection, zero tax sheltering, zero asset protection. It is merely a probate avoidance tool, which you have to be dead for it to happen. You see no benefit to this. I always say estate planning is one of the most thoughtful things that you can do. Okay, it's truly a thoughtful thing as far as, again, from an estate planning perspective. We use estate planning in life, right? So, again, back to the analogy here. This is your Instacart. Everybody has to have a will. Just because you have a trust, everybody has to have a will. Not everybody has a revocable trust. So, for folks with a revocable trust, you will have what's called a pour-over will. That's why I like the visual of water. You will literally have a pour-over will that then pours everything into your revocable living trust. The two things that you have to proactively do that won't automatically pour in, the two most common assets, American-owned assets, that pull folks into the probate process, unbeknownst to them, is real estate, ownership, and businesses, this law firm. Those are the two assets. So anything with a beneficiary designation form, if everything that makes up who you are involves 401ks, life insurance, stock bonds, literally stock bonds, anything with a beneficiary designation form, those Benny forms are a probate avoidance tool. The asset is the 401k. How it avoids probate is the beneficiary designation form. I had two guys come to me, two adults, 37, 41. Mom passed, and her two assets were a 401k and a life insurance. She never updated the beneficiary designations from her deceased husband 8 years prior. So the beneficiary designation forms were not accurate. Everything had to flow into probate. So it's not a done deal. You have to make sure your beneficiary designations are accurate, but if they are, you can automatically avoid probate. But your deed, if you own a home, does not have a beneficiary designation. It has title, a deed. This law firm is an LLC. It doesn't have a beneficiary designation. It has membership interest, corporation shares. So when we talk about trust funding and how to get things in there, it really depends on what makes up who you are. Okay. And then, but the goal is if you don't actually put the water in there, it's as if you've done nothing. From an estate planning perspective, you'll have the LGBTQ protections, but from an estate planning perspective, it'll be as if you've done nothing. There's a lot of people out there walking around with empty water glasses, let me tell you. They do the thing and then they don't do the thing. Okay, so what does the process look like? We handle businesses in real estate. It's retitling of property and doing an assignment and transfer of membership interests. And then we work with financial advisors in order to retitle any of the other types of assets. And so again, 3 legal financial, your durable power of attorney, 3 each, or 3 per person. And then the will and the trust. Also, I saw something about minor planning. If you have minor children, you will actually use the last will and testament. It is the only document who can appoint a guardian for children. No assets flow through here, but trust can't speak to what happens to humans. So the guardianship piece lives in here. Okay. And then the 3, what I call companion documents. Buddy, your time to shine. Oh my goodness. Anyone with any pups or cats or all the things, what would happen to them if something happened to you? Who is the cat person in your life? I just met with a couple this last week, I guess. 4 cats, 2 dogs. There's no one other than them that they know that would take all 6, right? So we're doing some serious planning as far as who would take what. And then I like to know who your vet is so I can make a phone call and know exactly they're 9 years old, get UTIs and on a special diet, all the things. And then an amount per pet for their care. Okay, and then we can talk about how to come up with a number for that, but an amount per pet. Cats are less than dogs. Dogs are dumb and eat socks and do, weird things. So, but those are the 3 things I like to know around pets. And then the second document is your agent for disposition of remains, or DOR, disposition of remains. Now, on its face, that document is super simple. What do you want to have happen? Cremation, burial, medical science, Viking funeral I did a few months ago, a composting, whatever you want. Cremated and then put in a biodegradable urn that gets planted and turned into a tree is one of the most common. I love that for you if that's what you want. So super simple as far as that. How I tie you together as LGBTQ folks is what's important. Okay, so again, if you're married, you are one another's legal next of kin. If you're not one another's legal next of kin, so it's especially important. But funeral directors are licensed professionals who can only speak to your legal next of kin. Okay, so if you are somewhere where your marriage is not recognized or you're not legally married, then the funeral director cannot speak to you. I had a client several months now, it was around Labor Day, Monday, and gave me a call, tell me this story. She and 2 other lesbian couples were in the Turks and Caicos on a scuba diving trip. One of the women had a scuba diving accident and ultimately succumbed to her injuries. And for the 2 days that she was alive in the hospital, her partner of 23 years, wife of 10, was unable to access her. And then when she passed away, nobody would talk to her about the legal documentation to medically transport her body back to Maryland. Sister flew in from Wyoming, homophobic sister, I may add, flew in from Wyoming, and the wife had no clarity, no control, no transparency, whatever the sister would allow. Okay, so ultimately, there is a statute in 49 states, not all 50, but if you move to Tennessee or live in Tennessee, we have a different way of shoring up this. There is not a statute per se, but we use a contract and we have a different document for folks there. So there's a statute in 49 states where you can appoint whomever you want as your agent for disposition of remains, and it's meant to be contrary intent to who your legal next of kin is, right? So if you're one another's legal next of kin and it's recognized where you are, then great, that will stand. But if you're somewhere where that's not recognized and or it's challenged in the state that you're in, you will always have that statutory appointment, that next level up. Super, super powerful. And then the final document is around tangibles, tangible personal property. That dog Buddha behind me has been in my family for 9 generations. Not really, it's from IKEA. But are there items that you would want to leave to someone in particular? So the default is everything to one another or to your person. But then what about any particular items? I'd say 95% of folks don't put anything on this document. You don't have to. It's the one document that is not signed by me, witnessed, or notarized. Okay, so in 15 years from now, you inherit grandma's rocking chair and you want that to go to your niece, dad's varsity jacket, grandpa's military flag, whatever it is. Lunchbox collection. One guy, a paint by number he did when he was in first grade and met Jennifer, his best friend. His husband jokes, babe, the only good thing about you dying is that paint by number will be off my mantle. So tangible items, whatever that may be for you. But again, it's something that you can update over time. It does not need to be re-witnessed or notarized. So those are the 9 documents. Again, the estate planning reasons why we do them, right? Probate avoidance, making sure people have healthcare and legal financial decision making for you. Then the LGBTQ reasons why we do them. The revocable living trust as your marriage protection tool, marriage recreation tool. I didn't actually talk about that as one last analogy about the trust. So 50 years ago, this became our marriage recreation tool. A creative LGBTQ lawyer saw how this was operating in everyday life and went, we don't have a way of binding ourselves together in the bonds of matrimony. But if we become co-trustees or successor trustees of one another's revocable living trust, that creates an impenetrable, inseverable legal bond. It's revocable. We can revoke it, but hostile family members can't. The government can't. Back in the day, it was mainly hostile family members, right? But now 100% of us have a hostile government, right? So it formed a bond 100 times more powerful than marriage because there is no power inherent in marriage. Then it created a repository for us to be able to put all of our assets safely. And then the win-win-win is it allowed us to claw back one of the most fiscally advantageous privileges tied to marriage. The government knows probate sucks. They created it to make money. So one of the 1,138 privileges is automatic probate avoidance upon the first of you to pass if you're married. Okay. So at a time when we had double probate, Angela dies, probate to Tom, Tom dies, probate. At a time when we had double probate because we couldn't get married, this allowed us to claw back one of the most fiscally advantageous privileges tied to marriage, which is estate privilege. So if you're in a state where it would go away, you would lose that probate avoidance piece. Super, super helpful. Again, the bond between one another with the durable power of attorney and the trust, you have decision making for one another over all the things 24/7. All right. So healthcare trifecta, the 3 legal financial documents, and then the 3 companion documents. I usually say then any questions, but I'm sure there are a lot, so I don't want to take any questions right then. I am going to do the design meeting and call up the person who won the first one. So there's another Pride Plans that we'll give away in the midst of the Q&A, so shortly. But the person who won is Stephanie Hansen. So I don't know where she is amongst all of these folks.
Hi, hello.
There you go. How do I... Let me do it, Jen. I want to do it. Look at that. I did it. All right, I pinned you. All right, so Stephanie, and who do we have?
My wife, Colleen.
Hi.
Right. Hi, Colleen. How are you?
Good.
Good.
My brain is full, but I'm good.
Yeah, it's a fire hose of information, but then, we work through it together. So first and foremost, so Stephanie, tell me, from a healthcare perspective, if you're both in a car accident together, and Colleen, so you're one another's primaries for all the roles, we skip right over that. All right, you're one another's healthcare, you're one another's durable, all the things. we skip right over that. So if you're in a car accident together and Colleen is unable, who would you want making healthcare decisions for you?
What, I'm unable,
Yeah.
and
Yeah, so
Steph is.
Stephanie's answering this. So Stephanie, Colleen is
Oh.
not able. Who would you want making healthcare decisions for you if Colleen is unable?
Probably I'd start with my mother and then work my way through to my brother.
Mother, and what's her name?
Lisa
Last name?
Hansen.
Right. And then, so for folks who are doing this at home, I believe that, so you can only plan on the accident happening tomorrow. I always say, do not disqualify folks based on distance or age. All right. Look at all of us. We can create intimacy. I have clients 3,000 miles away, internationally, all the things. Distance doesn't matter post-COVID. Neither does age. All right. So if we can only plan on the accident happening tomorrow, if mom is who we want tomorrow, then wonderful. Then we can have, and she already went there, an alternate to the alternate brother on her generational level to avoid an update in the future. Okay, but don't say, oh, but in 7 years, mom won't be a good fit, so I'm going to skip mom. Nope. Do mom, and then you can have another alternate and or an alternate after that. Okay. So just to avoid putting your personal information out there, I'll just put brother. Okay.
Okay.
And then Colleen, who would you want?
It would be my father.
Your father first, and then if he was unable, who would you put?
My sister.
Sister. And then we'll stick with you, Colleen. That's health related things. If you were unable to make legal financial decisions for you, do you like this order, your father, and if not your sister, for legal financial? Are they organized, manage a checkbook well?
I think that would be okay. I may have to flip it depending on when this comes up, but if it's tomorrow, then I would be okay with that.
Exactly. Yep. And then you can update at any point. Okay.
Okay.
So same order. And then for you, same question, Stephanie. Do we like that order, your mom, and if not your brother?
Yeah, that would be fine.
Okay. And then tell me do you own the house that you're sitting in?
Yes.
Mhm.
And married, not married?
Married.
Married. And we can either do two solo revocable trust or a joint revocable trust. And it really depends how you hold assets. Is most things jointly? How long have you been together? How long have you been married?
20.
Well, we've been married, like legally married, whenever it became legal. So what is that,
2013.
like 11
10 years.
years?
Yeah, 11, 10 years.
10
Yep.
years. Okay. We've been together for 24 years.
Okay. Congratulations. That's awesome.
Thank you.
So when people have been together that long, a lot of times money is like rinse, repeat, recycled at this point. You don't even know like whose is whose. Solo revocable trusts tend to be common, especially for younger folks. Not saying anyone's getting divorced, but folks do. And so by keeping things solo, you didn't commingle them, but you already own the home jointly. What other types of assets? You have 401ks, stock bonds, anything joint?
I have a 401k, and so that would have to I think probably doing a joint trust would be the most sensible thing.
All right. And then so when we do a joint revocable trust, then we have 4 people. We have Stephanie's mother and brother, and we have Colleen's father and sister. We have a joint document. So out of those 4 people, what order do you like that you're both in agreement with, that you both feel comfortable as your successor trustees? Would it be Lisa and then Colleen's father and then Stephanie, your brother, and then her sister? Like who's right off the bat, who's the most responsible out of these 4?
No.
Who would be the first person right off the bat? You're both gone. Who do you envision?
What did you envision?
I would go with my dad.
Okay.
All right. So
And
Colleen's father, and then who would be next?
Julie.
Okay.
Who's that? Your
Her sister,
sister,
And then mom.
and then
then
Lisa
my
or your
mother.
brother?
Yeah, then my mom, and then my brother.
All right, and then okay. All right.
Okay.
And then fun one. Do you have any pets? Actually, I didn't ask earlier.
Yeah,
You do have
cats.
two cats. Okay.
Hmm.
And so who is the cat person in your life?
That's tricky. I don't. We'd have to do some research on that actually. So I think if using the tomorrow idea, then I would probably put my friend Neil down. So
Okay.
I
All
think that
right.
would probably work out.
And I always say, so you're marinating on these, right? You'll be able to let this marinate further before you fill out the questionnaire and all the things. When I'm working with folks one-on-one, between the clarity between this design meeting and the draft meeting, the homework is to talk to these folks. Prior to the design meeting, you don't have to talk to anybody. It's just about you just thinking about who you would want. Okay, who would you want? And then going to them and saying, listen, I'm doing my estate planning. Here are the roles and responsibilities. I provide a 2-page primer that discusses the roles and responsibilities associated with each, and it helps facilitate that conversation. Okay, and then you confirm it when we meet again the second time. So basically after today and having conjured all this up, right, your homework will be moving forward to talk to these folks, including Neil. And then, like I said, the vet, and then the amount per pet. So a standard sort of thank you inconvenience fee is $2,500 for cats, $5,000 for dogs. Neil didn't think he was waking up, with 2 cats. So just a standard sort of thank you inconvenience fee. And something, while I say these numbers out loud, something to keep in mind is what is your person's financial situation? Right? Like, are they totally fine in the world and they don't need your money? Or would taking on 2 cats also impact Neil financially, right? So also play that in. But just a thank you inconvenience fee, $2,500 per. And then how you care for cats. So what would it look like for you? And then it's one lump sum. So we only do pet trusts around horses, tortoises, African grays, things that live 77 years, and one tortoise 150 years. It's going to outlive multiple caregivers, so there's going to be a trustee. Cats, dogs, one lump sum, but your cat could be 1 year old or it could be 14. So I would say figure out how much you spend per year and then choose 8 years. And that's a good in between if you're trying to just help put a dent in the actual expenses. Okay, different with dogs, different with what kind of dogs. Chihuahua 16 back here, right? So all different based on what kind of pet you have, but that's sort of how you get to a number. Okay.
Okay.
Disposition of remains. You want to be cremated, buried. I always feel like a server at a weird restaurant. Would you like cremation, burial, or the special this evening is medical science?
Cremation.
What do I want? I'd like to be turned into a tree that overlooks a beach.
There we go. I love that. And so you'd be cremated first and then put in a biodegradable urn that then gets planted there and will oversee the beach. And then the homework for you to think on your HVA. So the HVA2, the HVA1, there's no question for you on the HVA1. The HVA2 is the 3 groups of people if they apply. First, your chosen family, friends that are close like family, your one another's in-laws. You want to get them on there. And then the do not fly zone. Is there anyone legally related to you that you would not want to be able to visit you?
I can't think of anybody for me.
No,
That's good. Good. So then you'd get down those first 2 groups, and that's your HVA2 list. Okay. And then also at this stage, I then also say start looking for your deed. Okay. So you don't need it right away. The transfer of the house into the trust only happens after you sign the documents. can't transfer anything into something until it exists. Okay, but then once it exists, then we start doing the trust funding. So now's a good time to start looking for the deed. Okay. And then asset distribution. Is it this is what Tom was talking about earlier that confused a lot of people. It's confusing. Is it everything to one another? Stephanie, you passed away tomorrow. Is it everything to Colleen?
Yes.
All right. Colleen, you passed away tomorrow. Is it 100% to Stephanie?
Yes.
All right. So then if you both go together, right? If you both died in that car accident together, then what? And that's where people tend to get, stalled, if you will. So a way that I like to help people get unstuck with that. So we have Stephanie on this side, Colleen on this side. All right. Now, Colleen, sorry about it. You're on my left and I'm left-handed, so I always kill off the person on my left. Someone's got to go. So Colleen goes first and everything over to Stephanie, right? So Colleen had 100% of what she owns right now. And Stephanie has 100% of what Stephanie owns right now. Then 100% comes over to Stephanie. Stephanie lives another, this is what we got, right? So then Stephanie lives another 7 years with 200%. So if I met Colleen as a single solo person in the world, and I'm going to make this up, Colleen, and Stephanie didn't exist, and Stephanie says, I would love everything to go to my niece and nephew, 2 people. And then I meet Stephanie as a single solo person in the world, and I say, what would you like to have happen? And Stephanie says, I would like for everything to go to my mother. First and foremost, if she's alive, I want to take care of my mother. And then if she passes, to my brother, and then nieces and nephews. But we'll just put mom, right? So then we have this. But because Colleen died first, and everything went over to Stephanie, the 200% all goes to Stephanie's mother. Colleen's niece and nephew got disinherited by pure unfortunate fact that she died first. So what we do is we call it sweetheart dispositions. 3 and 3. It doesn't matter who dies first. So you have Stephanie's mom and Colleen's documents, and Colleen's, that's what we call joint contingent beneficiaries. Both of your people go in both of your documents. So it doesn't matter if one predeceases the other. Colleen went first. That's okay. Stephanie lived another 7 years. 50% went to Stephanie's mom, 25% to niece, 25% to nephew. Everybody, and as far as those percentages, you can do whatever you want. So some folks whack it up 50-50. Others say our money is rinse, repeat, recycle. So we're going to do 33, 33, 33. Right? And so you can do whatever you want. But that's the asset distribution piece. Okay. And then you would do an ultimate contingent beneficiary. It's the apocalypse now. Everybody who you've already mentioned has passed away. Then what? The default in my documents say charity, because I don't want anything to go to the state or government that, doesn't recognize us. But then you will put a charity of your choice, or maybe another family member, another friend, good old Neil, whatever you want. Okay. Now, any questions vis-a-vis your lives, about your own planning, anything while you have me that you want to clarify that you don't mind sharing out loud?
Well, one thing I was wondering, that you were talking about percentages right there with all of the beneficiaries. Is that also a place where you could say, a dollar amount that you wanted to set aside for somebody, and then
That's
also
a very
percentages
good,
or something?
Yep, that's a very good point. That's called a specific bequest. They come off the top. $50,000 to my alma mater. $10,000 to each niece and nephew. Whatever the case may be. We want it to be, best practice is under 75,000. We don't want anything big. Okay, so in 2008, when the last really big stock market crash happened, people were leaving big specific bequests, 250,000 here, 250. and then their portfolio went from 7 million to 1.2 million, and those specific bequests are mandatory, come off the top, and now their alma maters and their charities got everything and not their family. So if it's anything above, and that's not like a hard line rule in the sand, but anything above 75 to 100,000, turn it into a percentage of of your wealth. So even if it's 2%, whatever it is, like just build that in as a percentage. But yeah, those are specific bequests. They come first. And you decide, do you want that specific bequest to happen immediately when you die, before the 100% goes to Colleen? Or is it 100% to Colleen, and then when you're both gone, your specific bequests kick in?
Okay.
Go ahead, Colleen.
I have a question. We are very close to my sister's daughter, and my sister's son just died. So I would most likely have things going to our niece Natalie. But we also have a niece and nephew on Steph's side who barely know me. So how does that work?
Then you would just list that those would be your three people. Natalie would be one of them. And then, Stephanie's two would be one of them.
Right. And that's a place where we could designate percentages accordingly if we wanted to adjust that and give
Exactly.
one more than the other or whatever.
Yeah.
Okay.
And a lot of folks have Niblings, right? Children of their siblings, Niblings, nieces and nephews that are like your siblings, but your Niblings. And so, I don't know how old Natalie is, but a lot of my clients, we call it a next gen trust. So if there's anyone in your life, anyone who's watching, writing down their own plans, if you have 3, 4, 5 nieces and nephews that are 3, 7, 11, 14, my trusts go up to the age of 40. So anyone, it used to be 25, 30, 35. And now the brains of 25-year-olds are just not what it used to be. So now it's 30, 35, and 40. Okay, as far as any children's trust or next gen trust, whatever the case may be. And in the guardrails around the trust can go down. I signed off on termination. The trustee came to me, the kid was 36, mom's died when he was 12, and he was super, super responsible. Warren Buffett's mini-me, married, with child, owned a home, all the things. At 36, the trustee was like, can we bring the guardrails down? I'm like, absolutely. There's no point for 4 more years, of this. But I'd much rather bring the guardrails down than not have them up. 40's old. I'm 45. That would be weird. Like, it's hard to conceptualize, but like you bring the guardrails down if you don't need them, but you don't, at least they're there. So anyways, next gen trust, a lot of you may have your own children, so that would be a children's trust, or you want to leave things to minors that are again underage, and that's called the next gen trust. You loop them all, and again, maybe sometimes there's like 8 on Steph's side and 1 Nibbling on Colleen's side. So I've done the Colleen next gen trust and the Stephanie next gen trust. Right? So that way there's equal distribution to both sides of the family. Because if you left 50% to the next gen trust, but 8 belong to Stephanie's side and 1 belonged to Colleen, then 50% divided 9 ways, that 1 isn't getting that much. Right? So that's another thing you could do with your asset distribution. All right, any questions? I want to hop into Q&A, but any more questions from you guys on this that you feel would be helpful for you to fill out your questionnaire?
With the advanced directive, can you get fairly specific about like how in depth, like say like you want life-saving what's
Measures.
the word? Measures taken to a certain point, and then at that point,
So with that, so there's a section, and again, it depends on what state are you in?
New Jersey.
New Jersey. So it's everybody's state's healthcare power of attorney and advance directive and or DNR will be different. In yours, there's a section regarding that says other instructions concerning my care. And so for someone that wants something like what you just said, I'll have them at the signing write, I request that my above instructions go into effect X amount of days after I have been deemed to be in an end stage medical condition. Because it sounds like you want all the things, but not Terry Scheibode 15 years, right?
Yeah,
So
totally.
7 days, no more than 30 is sort of a legal number. After that, your health insurance is going to have to cover it, or your health insurance will likely stop. It'll come out of the estate and all the things. But so 7 is a big one, 5, 7, 21. But that's what you'll do. You'll handwrite in something like that. I request that my above instructions go into effect. So you'll put all do nots. You'll say you don't want anything. But then clarify, I only want that to go into effect X amount of days after I have been deemed to be in an end stage medical condition.
It's good. That's a good question. Good.
Yeah.
Thank you.
All right. Absolutely. All right. Remove the pin. Yeah, go ahead, Tom.
Yeah, real quick. Stephanie, I sent you a side chat just to get a little bit more information. I will be reaching out and coordinating with you to schedule a draft meeting to go over everything that you just discussed with Angela and to preview your estate planning drafts. And one thing I forgot to mention during our Q&A that I just want to make sure everybody is aware of, although LGBTQ plus Pride Planning is a streamlined online platform where you fill out the questionnaire yourself, you are not without help or guidance. We are always available. You can reach out at tom@prideplans.com or info@prideplans.com. If you get stuck along the way or need clarification or questions, we are always here to answer your questions. So it's not without help or assistance, but you do the questionnaire on your own, but we are here to help you if you run into any roadblocks.
Yep. All right. So we will jump into the Q&A. I'll start with Jolene because Jolene, your hand was raised forever. Do you still have a question or did it get answered along the way? You're muted.
Okay. Yes, several of them were answered. But some of them are, I haven't asked yet because I'm not totally sure how
You're
to
still
word
so the main ones were answered, but you're processing on the others.
Yeah. Like for example, long before I came out as trans and was still pretending to the world that I was male, I had family who disinherited me because they chose their religion over their family. And so therefore, my partner and I don't want them anywhere near anything either of us have. And there's also the fact that right now I'm receiving assistance because of different health issues and so forth that where it kind of makes it difficult to have a full-time job with real insurance and all that good stuff. So we're in kind of a unique situation that even if we can get married later on down the road, it cannot happen until I'm at least 65. And
yeah, so
and that if anybody tries to say anything, he's got all the legal documentation and everything else to be able to tell them to STFB and STFU.
Exactly. Yep. So like I said, these documents we've been using for decades to recreate a marriage. So it's absolutely, and a lot of my clients don't want to get married. They want to live as they are and don't choose marriage purposefully. And so these documents are what you will be able to use to protect one another. Also, not wanting certain family members around anything. There's, like I said, there's the hospital visitation form, which will make sure that they're not allowed in the hospital. But then in your documents themselves, in the will and in the trust, you can have a disinherit clause. So a lot of folks will think that a will contest clause, it matters. The only way a will contest clause helps is if you actually leave a lot of money to the person, enough money that they choose the money over the will contest. So a will contest means, think of playing Scrabble. We're playing Scrabble. I put a word down. You want to challenge me that it's not a word. And if you do, and I'm wrong, or you're wrong, rather, you lose a turn. Right? And so the will contest is, here's $50,000. If you contest this will, you don't get the $50,000. Right? And then, but if you do and you lose, then you don't get I think I said that backwards. But if you do contest it and lose, you don't get the 50,000. And if you don't at all, yeah, I did say it right, then you get the 50,000. Now, another reason why the revocable trust is super helpful, Jolene, is it removes you from the probate process. The probate process is where the will contests occur. So you're not even going through that process. That is the whole point. That is why we've been using it for decades. So the revocable trust, if your relationship is a castle, the revocable trust is that moat around the castle. But we can still put disinherit clauses in there to make it super clear. For the purposes of my asset distribution, have disinherited so-and-so. It's like a dead to me clause. This person is deemed to have predeceased me. I have made no provisions for them. Okay, so you can still add that language to be super clear.
Yeah, because with us, it's not his family I have to worry about.
Right.
His family has welcomed me with open arms. It's my side.
Right. Well, we'll protect you against that.
Have been the real SOBs, and they're the ones that would
come out fighting.
That would try to deny him what's rightfully his.
Right. Well, we'll help you protect against that. Jennifer Edwards, go ahead.
Hi, thank you. Can you hear me okay?
I can.
Okay, perfect. So I work for Modern Military Association, and we are a group of LGBTQ plus military service members and families and veterans. So specifically, my question, you had mentioned before that when you move states, it's advised to update your power of attorney to the state in which you're permanently residing, and then also updating your will to be in the domicile to be domiciled in a state where you live. What would you advise military families? Oh, hi, Serena. What would you advise the military families do when they're moving like every 2 to 5 years? Should they be updating that with every new place they live, or no?
Yep, absolutely. And so personally, just because a lot of my clients are, and thank you for everything that you do. A lot of my clients are military folks. I have a deeply, deeply discounted update rate for my military clients. Because I know they're going to update every 2 years. And so as long as all we're doing is updating for the state, and they're not like rehashing their entire estate plan each time, right? Like, let's change the percentages here, and I don't like this person anymore. And, as long as it's literally, hey, we're going from Nevada to South Carolina, I need South Carolina docs. Then I basically do the update at Pride Plans costs, like super, super, just plan for it. But most firms aren't me, and it would just be an update, and it's unfortunate, and so many military folks don't do that.
Right. It's very basic what we are told to do, and so I think that especially for our community, this is just really vital.
Right. Well, I'd love to talk to your group. So
yeah, we'd love to talk to you. Definitely so excited to be here, and thank you so much for this. So
absolutely. Zaid, good.
Hi, this is Zaid speaking. I have a few questions related to the trust. If we own properties in different states, mind you, do they all get added to the trust? I know you explained how the cup gets filled afterwards, but would we need to then, I guess, go update the title? Does that all get updated separately? Do we need to pay the fees and do that administrative processing on our end with our the respective municipalities after we have everything notarized?
So that's a very good point. I didn't bring this up earlier, but property in multiple states is an absolute sort of CYA around probate. So the laws were written 250 years ago. They didn't think our horse and buggy would be able to get from Pennsylvania to San Diego to Arizona. Where are your properties?
New Jersey and Washington, D.C.
Okay, well, they're close, but still, the horse and buggy wasn't going down that way. And so the laws are such that you have to go through probate in every state in which you own real estate, and the state in which you reside, and the state in which your documents are governed, right? So if you're Jennifer Edwards and your documents are in South Carolina, and then you move your station, now you move this, over to Nevada, and then you have property, and then from Nevada to Illinois, but you bought property in Nevada, but now you live in Illinois. Now we have probate in in 3 states. The documents are under South Carolina, own property in South Carolina and Nevada, and live domiciled in Illinois. You can't give Illinois a South Carolina document because they don't speak the same language. One speaks South Carolina, one speaks Illinois, right? So you'll choose New Jersey. You said Jersey and DC. Which state do you live in?
We live in New Jersey now.
Okay, so you'll choose New Jersey, I guess, right? And then from there, you will transfer the DC property into the name of the revocable trust. That process, if you're doing it on your own, and for Pride Plans folks, we help Pride Plans clients do it in a discounted fashion. So we charge $950 per property, and for Pride Plans we charge $750 per property. And so you'll need the recording fee to the county in which it lives and a quitclaim deed. And so you can use a title company, however you want to get it done. But those are the things, and then it gets retitled into the revocable living trust of you. Same with Jersey. Even though you're in Jersey and the documents are in Jersey, you still need that Jersey house in there. Okay, you can have a mortgage, it doesn't matter. And some folks want to get approval from their mortgage company. We just had clients that had to call 3 or 4 times before they finally got someone at their mortgage company that knew what they were talking about, and they finally got the approval letter. A law passed in 1984 making it absolutely allowed to transfer property into your revocable trust without triggering the acceleration clause. Okay, so that's what you would do, is transfer. Basically, you're retitling each deed.
And if the DC property is currently rented out, I mean, is that opening our entire trust open, to lawsuits or liens and whatnot if that person decides to sue us for whatever reason, for example?
No, I mean, if
still
they decide to sue
protected?
you, they're going to sue you anyways.
They can't put a lien on the entire trust because that house has been within that?
Yeah, no. Yep.
Okay.
Yep. And again, I mentioned earlier, with this type of trust, there's no creditor protection, no asset protection. It's an alter ego of you. It's as if you are transferring from you to you what you already own, just inside this probate avoidance bucket.
Right.
But it hasn't changed anything. So even if this didn't exist, right, they would still sue you as homeowners. And so the best way to, get into a different topic, but the best way to limit liability is to be properly insured.
Okay.
Insurance is the best way.
And then one more unrelated question regarding beneficiaries and folks that we would list on the will or within the trust. If we have folks who are overseas, non-Americans, Brits, for example, whom we want to add to the list of beneficiaries, how does that work? Or visitation, for example, if we have foreigners that might not have a social security. I don't know how these identifiers are used to identify these persons
you
overseas.
can leave assets to anyone you want in the whole world. Every country has treaties and probate treaties with one another. So the one thing I can't say right off the bat is what the tax situation will look like for that person based on the country that they're in. But you can absolutely, the one issue is whether folks want them to be an executor or a trustee. And they're overseas, then it could be deemed a foreign trust and all of these things. But just getting money from you, assets, bequeathing, and or visitation or health, and that's totally fine.
Okay. Thank you. Much appreciated. Thanks.
Absolutely. Wade.
Hey there, can you hear me?
I can.
Okay. So we are in the process of trying to relocate outside of the country at this point. And so we still have a home, we have vehicles, we have assets, and I'm going to be going through the process of getting everything put into the trust and whatnot here. But as we start to remove these assets, and we sell the house and the cars and all that kind of stuff, and we're in a foreign country, do we have to reestablish a trust there, or is it something that's transferable from the U.S.?
Yeah, no, I mean, it's not even transferable from South Carolina to Nevada with Jennifer, right? So at the end of the day, what you'll do is once you've established residency, permanent residency, citizenship, you know, in the country that you're in, then you will find an estate planning attorney there. So exactly what you just said, anyone looking to leave the country, you still need to do your US based estate planning to get your foothold here in the US properly secured. Then you leave. It sounds like, Wade, you're going to be selling some of those assets. You may still have a 401k or some financial accounts here. But then when you end up in your destination country, after you've been there and you're established there, then you will find the estate planning version there, like an estate planning attorney there. And you just want to make sure that the two speak. The two estate plans speak. So again, each country, as I was saying previously, each country has treaties with one another, and how estate planning needs to be done from an expat who is now, are you completely defecting? Are you letting go of your US citizenship? There's some things I don't know that would impact that, but the answer being is it's absolutely not transferable. They are valid, like your healthcare power of attorney, durable power of attorney. If you were traveling the world, those documents are valid where you are. But you can't put your home in Portugal inside of your US based trust, basically. Okay, so you
Okay,
will
so
have
we
two
just need
estate plans, and you need to make sure that they don't, Ghostbusters green line.
Okay, perfect. So just in other words, because we do have an attorney over there already,
Perfect.
and we're setting up a financial account and all that kind of stuff. But do we even add that into the trust here while we're still here? Once we
It's
have
a
like a foreign
financial
account
account
set up?
in that country.
Yeah.
No. I would
Yeah.
confirm with your lawyer there, but my first take is no.
Okay. All
Yeah.
right. Yeah, that's all I
Good
needed to hear.
question. Absolutely.
Thank you.
Darrell,
Hi, can you hear me?
I can.
Okay, perfect. Yeah, so I'm also a military spouse. I currently reside in Georgia for work. My husband actually, his residence is in Oregon. We both have assets and pets in either state.
Mhm.
He's actually currently located in Virginia, and soon will be on an aircraft
Darrell, it's
carrier.
late. Why
And
are you
so
doing this
I'm
to
sort
me?
of, so I'm just
Um,
it's with us not living together here, and I know he's going to be leaving the country. I'm kind of like, okay, so is this something where we would be drawing up these documents in both Oregon and Georgia? Um, yeah, I'm just kind of worried about that.
yeah, no, I just met with a couple actually, and Tom, let's do the second raffle, the giveaway. I don't know why I called it a raffle, but soon, after Darrell's. So I just met with a lesbian couple, Hawaii and California were there too. What I would recommend is, you're Georgia, you said?
Yes,
Darrell, you're
I'm
Georgia,
currently in
he's
Georgia.
Oregon.
Yes, but he's technically in Virginia right now, but all of his assets and things are back in Oregon.
But is he residing in Virginia because he's in the military, like work-wise?
Yes, for training, and then he'll be leaving here in a couple months to go wherever the aircraft carrier
So
happens to
he's a
be.
resident of Oregon. Virginia is just where he happens to be for work right now. So really the only two states at play are Georgia and Oregon. And what I would do for you guys, if I was working with you, I would just do two separate, I would just do Georgia docs for you and Oregon docs for him, ultimately, because that's where you're a resident of, and then and vice versa. Virginia is not legally in the mix. He's just there temporarily.
Okay.
But
Okay.
you don't
Perfect.
each need documents in either. I would just do Georgia docs for you, Oregon docs for you, and then when you come together and that changes and you're all in one place, then you can update for what that particular state is. One of you would update, or whatever it would look like.
Okay. Perfect. Thank you. Thank you so much.
Absolutely. You're welcome. All right, Tom, you wanna, or no, Jen. Jen does it. Yeah. Are you co-host? Do I need to?
Nope, I got it.
Okay.
I'm just pulling stuff up, making sure I'm on the right page. All right.
There are 1,200 people. There are real names on that thing. There's over 1,200 names written. Ding, 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 ding. It's
All
Chris
right.
Sanchez on. You have to be here, so we may have to keep going. All right. Not here.
All right, I spin again.
Yep.
All right.
If we have to spin more than 5 times, then we'll pick some other way or something.
Okay.
Everyone saw us try. Lilia. All right. Take 3. I mean,
All right.
1,200 people, 200 are on. Like,
I know.
Nicole, are you on? All right. Take 4. Nicole?
All right.
Nicole, raise her hand.
Yeah.
I think so. I saw Nicole B.
Are you looking at the chat as well?
I'm here.
I
Oh.
see. Yeah. I can't see her though. Oh, because you're sharing.
I'm stopping my screen share.
Nicole B. Right there. All right, awesome. So Tom, there we go.
How are you?
Good. How are you? Congratulations.
Congrats. So
Thank you.
Nicole, there we go.
My video is
Nicole.
a little slow, I think.
Yeah, we'll get your
my
contact
wife.
information before we lose you.
Yep, Nicole, I'm gonna send you a side chat here just to you to get your information, and then I'll reach out to you with an email shortly.
Congratulations, Nicole.
Okay.
Brian McGrail, what's your
Thank you.
question? You're welcome.
Hi, how are you?
Hi, Brian.
So my husband and I are currently in the process of an adoption. So it's kind of a two-part. Should we start this process now or wait till the adoption's complete? And then also, do you at all provide any adoption services to help with that process?
What state are you in?
California.
Okay, so I have the California firm that I work with as my co-counsel does. So, I can put you in touch. With estate planning, I can work with folks directly, but with adoption, we need to file things. So someone with an attorney of record that is, needs to be the one filing. So I will be involved and assist, but they would actually be the one to file. And then you're in the process of adopting babies born?
No, we actually just got selected. The baby's due April 13th.
Oh, congratulations.
Thanks.
That's exciting. So you could do one of two things. You are able to say sort of a vague, blanket for the children piece, like do your estate planning now, and then in the child, not actually name the child, but just say in any child born to or adopted by me, then create the children's trust and all of the things, but the name won't be there because you don't know that, right? And then you can update it after and add the name or not add the name. Like it's meant to be that if you had one child or 4 children, like no one's disinherited because it's, my child and any child owned or, owned, born to or adopted by me. That the other one is for pets. And since neither you and your husband are giving birth to the child, I don't have a concern over one of you passing away during childbirth. So, as an estate planning attorney, I have to say you could get hit by a bus tomorrow. So I would want you to have your estate planning documents sooner rather than later, but we know that you have an update coming literally in 4 months to the day when you like know the baby and the name and all the things. So I think it could, can't say you should wait. You could get hit by a bus tomorrow, but I said that and and then you decide for you how you want to do it, but
Okay.
it just makes sense to add the baby's name and all the things.
Perfect. Thank you so much.
You're welcome. And Brian, you can also go ahead and take advantage of the discount, buy now and just not do it until later.
Okay. Awesome.
Yeah,
I
that
appreciate
makes
it.
sense. You're welcome. FJ.
Hi, can you hear me?
Yes.
Hi. So I my wife and I are in a mixed status couple. So I'm a DACA recipient. I also work for an immigrant rights organization here in California. So now that we're helping folks with their family preparedness, we have a lot of same-sex couples that have similar questions around, so similar to a medical directive, is there like a waiver or a document that can be used if a spouse needs to visit somebody in detention? So like immigration detention, or if the person is removed with the like trust, whether there's a trust here, is there a way to enforce it, or what like mixed status couples can do, especially right now?
So one of the legal queer A's that I did was around detainment and documents that Jen, if you want to share that at some point. And so take a look through that. There's a lot of resources for folks in that I put together. There's not, if you're detained, you don't have due process. So there's not a waiver, there's not a letter, there's not like a version of this, like this person is allowed to visit me. So there's not a document that would be enforceable. But in this detainment packet that I came up with, there's a lot of good resources of like letters pre-prepared to go to landlords about, pet care people, just all of the things. So we'll get you that. And then if there's anything there that you can use with your folks, please do.
Perfect. Thank you.
Okay. And also, and I should have said this earlier when there was more people, but to you guys, I, at the beginning of the year, started a school community, SKOOL. The link, well, Jen will put it in, it's Your Gay Lawyer School. And it's, again, a place off social. So I have Legal Queer and A every other Tuesday at noon. I do the Legal Queer and A's where I talk about a topic and answer any and all questions. The school community is meant to be where the Legal Queer and A folks or folks who want to meet more consistently or just get information more consistently. I have information that's behind paywalls that I'm not allowed to publish because they belong to law.com, but I feel safe, just publishing them privately in our private group. iHeartMedia shows, just other content that I can share with you, everything I've ever done, how to leave the country inexpensively and creatively, and documentation around that, the detainment seminar that we did, the Exclusive Citizenship Act, all of these things, and I'm creating all of this PowerPoints and letters and packets and all of the things, they're all in the school community. So it's basically a platform where everything lives. So if you want to join, go ahead. It's at school, Your Gay Lawyer, or something like that. That's why Jen has the links. And it's awesome. So I'm building it all of 2026. We're going to have 2 in-person events, one on the East Coast, West Coast, and it's just about staying in community. That's how we're going to get through this. Social media is great and all of the things, but how we really truly get through this with peace of mind, sound mind, mental health, and all the things is with each other. So, Jenna, go ahead.
Thank you so much. My partner is trans, and I am always worried about like passports and how, the ability to get a passport renewed. What do legal names look like? So I guess my question is 2 parts. One, how do we ensure that these documents that we create with legal names, a lot of his documents have been changed, social security card, driver's license, birth certificate, all of that. But, if the world goes to crap, how do we help ensure that, if that name is no longer recognized, that person is still recognized? And two, if I had further questions about passports for US citizens, what would be my next step for working on that?
Yeah, so as far as the name change piece, so the name change, that's a court order. It's a court decree. It's a name change decree. So as I just and I'm going to do more on this particular topic, but the Lemkin Institute came out with a study that were like 8 stages of 10 into legal genocide. Well, I call it a legal genocide. They call it a process genocide against transgender, diverse, intersex, non-binary folks. And so, the way to fight a legal genocide, the reason why I call it a legal genocide is what they're doing, have been doing for years, but obviously more systematically since January 20th, is making it so that trans folks don't exist on paper and then use that paper reality to then control their lives, right? And so how you fight a legal genocide is you fight legal genocide with legal documents. If they're trying to say you don't exist, then you make sure that you do exist on paper. Okay. And so as far as the name itself, that is a court decree, just like an adoption decree. Everybody, there were some questions. I went through the surveys that you filled out. And there were a couple folks that are like, do we need to adopt? We're both on the birth certificate. Women, especially men, know that they have an adoption process they need to go through. But yes, you I lost my train of thought how I got off on that from trans of adopting. But anyways, legal genocide, fighting legal genocide with legal court order. Adoption decree is the only true form of parentage is the adoption decree, and it can never be taken away. It's a court order. The judge signed it. Nothing Trump can say can rip up that name change. Gender markers, however, different story. They can be reversed. They're in the midst of doing that. In Texas, you're no longer allowed any gender marker changes. So it really depends where they are in their transition. But the number one thing that I would say for transgender, diverse, intersex, non-binary folks is do your estate planning. Get on paper who you are, healthcare powers of attorney with additional gender affirming care riders, durable power of attorney to make sure there's someone that can make legal decisions for them. So, those are my thoughts on that. What's your passport specific question?
More specifically, I just had questions related to renewing his passport down the line, just for his very specific situation. Has had a passport before.
How many years does he have left?
He has like 3 years left. Exactly that. So I would like to talk to somebody about that. Like, what would be, am I looking for a family lawyer? Am I looking for an immigration lawyer? Okay.
There's nothing you can do about the passport.
Unfortunately. Okay.
Yeah.
Thank you for that information. I appreciate it.
Big hugs. Yeah.
Thank you.
Graham?
Yeah, it's Graham.
Okay. Yay.
All right.
Go ahead.
Okay. The situation I have is me and my partner have been together for like 24 years. We live in my home. We have kept our finances separate. So the house would go to my daughter, but I want to ensure that he is able to live in the home and if I go before him.
Okay. So you would do a life estate. You'd have a life estate. It's called a life estate. That may not be a Pride Plans thing. I'm not sure. There may be, again, when you fill out the quiz up top, a lot of people email me. They're like, I failed the quiz. What does that mean? You didn't fail. There's no failure. It just means that the one size fits all thing is not, necessarily for you. But very easy to do. You create a life estate in your partner, and he can live there for his lifetime or as long as he's in the home. And then upon his passing or upon his leaving the property, then it transfers to who you want it to.
Okay. Thank you very much.
Absolutely. And then, did I get through all the questions? What? Are there more questions that Jackie did not answer in the chat?
Most questions have been answered in the chat. Like, holy cow. There's a lot of questions answered in the chat. Yes.
He's saying Jackie did a good job. Yay, Jackie. So, nope. Hold on. I don't know where the hands went. I saw two people had their hands raised, but they're not. Oh, they're there. Oh, it's Tammy Ray.
Hello, Angela. You mentioned there's
Hello.
nothing new about the passport, but if the passport's already been corrected previously and issued to you before this change that they have now, they should just honor the passport being updated with just continuing showing of the same information, no?
Nope.
If
you
the birth
submit for
certificate changed,
renewal,
driver's license changed, social security's changed, they can reverse it still?
correct. That is absolutely what's happening every day. I'm getting calls. So a friend of mine submitted his for renewal. He had 2 years on it. The window opened between July and then it just closed recently. He sat on it for too long and submitted it for renewal, and he got caught right when the laws changed. So he had 2 years. He could have enjoyed the 2 years that he had, and he got it sent back with an F.
Not good.
There are no renewals. The law, I mean, they've been very clear on this. They've been saying you have for as long as you have, and then upon renewal, it'll go back to your sex assigned at birth. And then for about a day, they said, or until we, not disqualify it, but there's a word, but basically render it null and void. So they were just going to pull everybody. So there is a potential that like even that 3 years would be taken away. But that verbiage sat on the website for less than a day, and then they deleted that verbiage.
And concurrently, they want to throw us out.
Yes, yes.
Yeah.
Okay. Well, good to see you.
You as well.
All right, Fabian.
Hello, can you hear me?
Yes.
Hey,
Is that how you
Fabian.
pronounce your name?
It's actually Fabian's my wife. She's just wrapping up dinner, so thanks so much for the webinar. Wrapping up, perfect timing. But my name is Sunny. I am a newbie to Northwest Arkansas. Came from Colorado, newlywed. And thank you so much for all the info. We are going to reach out and probably work with you. Are you touring through this area?
I
Fabian,
am.
Arkansas? Ooh,
Yep.
I'd love to meet you. You got good vibes. You
Absolutely.
got good energy. And I want to help in any way I can. If there's people out there that need information and like I can help distribute it, like I don't have
That's
a job
awesome.
right now. You don't maybe have to pay me. I might volunteer. But
I
just
love
want to
it.
I want to say thank you, and I'll look for your tour info. I'm gonna reach out.
Big
And
hugs.
that's about it. That's all I got.
Enjoy dinner.
Yeah, thank you.
All right. See you soon. Bye. Lisa.
So my wife, I'm covered under my wife's federal healthcare benefits, including medical benefits. Do you have any ideas if our marriage was taken away? What would happen with our my federal benefits under her, or anything I can do in our planning?
Yeah. Well, there's nothing in the planning that can be done to secure those. And, you know, again, if this is your marriage, these are the federal, out of the 1,138 state and federal privileges tied to marriage, the silver here are your federal. There is nothing that any of us, Sunny, who was just on, that came from Colorado but now lives in Arkansas, right? There's nothing that any of us can do from the bluest of blue states, Colorado, right, if the Respect for Marriage Act is circumvented. And again, the oral arguments that were heard today will likely be very influential in that. I'll do more on that in the next legal Q&A. But the bluest of blue states, there's nothing any of us will be able to do if they find a way around the Respect for Marriage Act. Then the orange, this is Obergefell. So the headlines are really leading when they say marriage equality. And P.S., the Supreme Court not taking the Kim Davis case didn't mean anything. I'm sure you all know that, but just repeating it. these headlines, Supreme Court upheld Obergefell. No, they didn't. They just didn't take her case. They didn't uphold anything. It was a complete just, look here while over here, this is happening, right? So that literally meant nothing. They were never going to take that case. But if the Respect for Marriage Act is then, not repealed, they can't repeal it, but eviscerated, then this will depend on where you live, right? Arkansas, Tennessee, Georgia, Florida, and then you have this. So there's state and federal benefits, rights. Okay. And so as far as the federal, we didn't have them before, right? We got them over time. And so depending on how things go and how ruthless they are, I don't think they would have any qualms going back to a world where we didn't have those benefits associated. But I don't know per se.
Yeah. That's my fear. So
yeah.
thank you.
Yeah. We stopped in Little Rock, Arkansas. We were in Arkansas.
Little Rock.
Little Rock.
That's like a few hours south. My wife's family lives there, so we'll bring the kiddo. We will leave the dogs at home, but we'll definitely make that drive. And was the last question about the validity of a marriage license in a different state?
No. Okay. I was just using a blue state and a red state, and you were in my head. Yeah.
Because we got married in Colorado, because I was like, Colorado is going to be more like gay marriage, fuck yeah, and then Arkansas, right?
Yeah.
So what can we expect if with an out-of-state marriage license? Is that anything to be scared of? And
you don't need to necessarily get married in a blue state. It really doesn't matter per se. It really depends how the Respect for Marriage Act plays out and whether full faith and credit will be given in the state in which you live. If you live in Tennessee and they don't want to recognize marriage, it won't matter whether your marriage certificate is from Arkansas or Colorado. Tennessee won't care. So it's about, if we get to that point, it's about being able to live in a blue state, ultimately. All right. Well, I look forward to meeting you.
Same. Thank you so much, and for all
You're
that you
welcome.
do.
All right.
Bye.
Rowena, good to see you again. It's been so long. Saw you at noon for Legal Q&A. You came back for more.
I actually took your advice and I look up Curacao and even spoke to some people. It is fantastic that it's an option.
People, I'm going to Curacao. I'm buying a gay bar. You're all invited. All right, that's my place.
Send us all the
I'm gonna turn that island
gay as a rainbow.
Exactly.
The reason why it's important that we get some assets outside, or for me anyway, is that for mental safety, right? We want someplace safe. But outside, one of my question, a lot of Zaid actually answered his questions, answered all mine. But following up on the healthcare issue, is there a way that we as a LGBTQ community can have a buying power as a group to cover our community like a small business?
Yeah, I mean, some of the things you brought up there in the Legal Q&A, as far as like, having an international community and all of these things, it's an undertaking. I don't know of one. I don't know of a group in the United States that has managed to do that for any community, right? So, but that would be amazing. I mean, I'm a big thinker, and I love where you're going and all of the things. And so make it happen from Curacao.
Yeah, we're definitely gonna happen. I actually spoke to, I'm with Out Montclair, and that's
oh yeah,
right. So I will bring it up at one of our meetings if there's a possibility that members can come together as a buying power for healthcare, because it's ridiculous.
With that, I would start small. I would say that you want to cover 10, folks and their healthcare and grow it that way, instead of like the community, like covering the entire LGBTQ community, but really who's most in need. Trans folks, making sure they that they have access to gender affirming care, all of that, and then start small and make it a nonprofit. I can help you with the 501c3 application pro bono, and then go from there.
Is it possible that you can, I know you're busy and you have a lot of clients, but my email is there. When you're available, maybe I can meet with you somehow and we can do something for our community.
I'm there. I'm doing it.
Okay.
All
Because there's
right.
a lot of stuff I'm trying to do to raise money because we can no longer get money from companies. So we're trying to do different things to try to fund some of the programs now. So this is like we have to take responsibility for ourselves now, our community. So
And
yeah, when you can, thank you.
all right, thank you. Thank you for what you're doing. I saw a question, I think maybe it was in the chat because it went away, but around moving money, transferring money somewhere else, and we talked about that at the legal Q&A as well. So something I suggest for folks is opening up a Coinbase account or a Binance account, crypto, not to invest in Bitcoin or anything risky, but just USDC stable coin. It's $1. It doesn't go up, it doesn't go down. And putting money there. So it's not in any bank account. There are folks that are opening banks in countries they don't live in. They're just foreign countries, especially Canada. People are just driving up to Canada and opening up a TD bank account and putting like 300,000. Like, don't. You're triggering stuff, accounting nightmares, potentially the Foreign Corrupt Practices Act, because they have no idea why this non-citizen just stashed 500,000 into a foreign bank account, right? It just rings of corruptness, even though that's not why we're doing it. So cryptocurrency is a great, safe place because it's called a stable coin. And then it's up here, and then you go, wherever you are in the world, and you pull it down from there. No tax implications. You didn't, trigger anything. You didn't make anything. You didn't lose anything, but you're just putting it somewhere other than a bank here and other than another bank in another country. So between your mattress, a bank here, or a bank in a country, you don't have many options. All right. So it's a super, super solid way to get money out into the ether that you still have full control over, and then you figure out where you're going to land as far as home base. What other questions may not be estate planning based, Jackie, if you see any? Oh, there, Yash, that was the one. CFPs, yes. Email me on that. I have great folks, both CPAs and CFPs. So if you need an accountant and or financial planners, reach out. I can definitely put you in touch. Yes. Captive, property and casualty. Not Atlanta, like Jen said. I think I saw something Jen say. I won't be in Atlanta per se, but nearby. Any other questions? We're over time, but I'll stay if you have them. Can you repeat? USDC, stable coin, but just look up stable coin. There's a couple, but that's basically what you want. You want it to be a stable coin, not anything that you're, actively investing in. Connecticut is not on the tour. No, it's mainly meant for rural and underserved areas, but I stop in, medium metro cities. So as to keep folks safe, I don't want to go too rural with the caravan. It's 32 feet long. It's all gate out and all the things. And so if I went into a really rural town and asked people to get on the caravan, they'd be outing themselves. So I go Charlottesville, Virginia and Little Rock, Arkansas. So they're cities, but they're medium size. Stroudsburg, yes, near there. We're stopping somewhere near there. School is a online platform. I've made it completely private for us. In there, there's modules. As I, with social and this, I do a lot of written content. People like to read. Not everybody wants to consume information in this way. Some folks just want to read all these things. So it's a place where my written content content can go. With every legal Q&A, there's a PowerPoint. That's where the detainment packet lives there. The all the different countries that you could potentially expatriate. That you could expatriate to live there. So it's basically a hub where folks can join, and you'll introduce yourself. You can leave comments. People leave threads. I will post regularly on something, and then comment on it. And so it's basically a way to stay in community and have access to all of the content that I'm putting out there in one place instead of going to, a bunch of different places. So, anything else? You guys were all absolutely amazing and lovely. Let's see.
Yes, thank you, everybody.
Yes, you're absolutely amazing. Like we said, the discount will be live through Friday through Pride Plans. If you're interested in working with me, I don't know what state you're in, just reach out. Let me know, and then we can go from there. And join us in Legal Q&A. The next one is on the 27th at noon. And then as well as in the school community. And there's a calendar also that keeps you updated on any of the things that I'm doing. So, but truly, truly, all wonderful. Happy Tuesday. Nico loves you as well. Oh my goodness. Oh my goodness.
Hello.
Bye, everybody. Thank you.
All right. Have a great night,
Thank you so
guys.
much.
Absolutely.
Thank you.
You're welcome. Bye, guys.